didn't read through it all.
All right, folks, we're going to go back on the record.
All right.
Mr. Gallagher, your closing statement.
Let me start by thanking the board for this opportunity to present Mountain Trail's application. Over the past 3 years and approximately 25 public meetings and hearings, we have listened to the communities and the township's concerns and comments about the proposed solar project. In response, Mountain Trail has made a considerable number of revisions to the proposed design of the facility, many of which go above and beyond the ordinance requirements. As Ms. Fowler noted, before the hearing process began, several residents addressed their concerns and opinions with respect to a number of issues, including stormwater, property values, environmental impacts, and health and safety concerns. And as I did say in my opening statement, Mountain Trail is not dismissive of these concerns and opinions. However, it had to be noted that many of them are not relevant to the determination of whether the application complies with the conditional use standards. Nonetheless, I told you Mountain Trail would address both the project's compliance with the relevant standards and the community's concerns. I promised you that we would demonstrate that the proposed facility is a safe, passive, and beneficial use that complies with all the township's requirements. In order to do this, I told you we would present a number of subject matter experts from across North America. We did exactly what we said we would do. Mountain Trail retained Kimley Horn, which is one of the nation's premier planning and design consulting firms specializing in solar development. Mr. Hughes, who's the Vice President of Engineering, outlined the numerous environmental studies that Mountain Trail conducted in support of the project, including the comprehensive and very conservative preliminary stormwater management design report. He also explained how he worked closely with the township's engineer to modify our design and to be more conservative than Pennsylvania Department of Environmental Protection guidance. He also explained how the township changed its position on certain interpretations after the application was filed and the revisions that were made to address the same.
What positions were changed?
The lot consult that we had originally, the Gasperi and Frederick parcels were considered one lot, and we were told at the Planning Commission that they had to be treated separately.
Who told you that they didn't have to be treated separately?
I'm sorry?
Who originally, you said the township?
Well, we had gone through, we submitted the application, and we went through 2 Planning Commission meetings. And then we got a unfavorable recommendation, and there were many, Mr. Hoffman, as well as the Planning Commission members.
So would you agree that no determination had been made prior to that recommendation?
No, I don't know that. We had review letters and we just complied, and there was no issue that was ever raised by the township before that meeting.
Very well.
In Mr. Yu's expert opinion, the project will comply with all applicable ordinance requirements, and Mountain Trail will obtain all necessary state permits for the project. Tad Henry from Kimley Horn, a noise specialist expert, testified about the noise study for the project. In his expert opinion, the proposed facility complies with the township's noise regulations. As Mr. Horatio Larios confirmed, Mountain Trail will perform a post-construction noise study to confirm that the operational sound levels comply with noise level requirements. Mr. Andrew Lyons testified to the lack of property value impacts. Mr. Lyons has the highest designation as a real estate appraiser can obtain. He has performed numerous studies on the impact of solar farms on property values. In his expert opinion, based on actual home sales, the proposed solar project will not have a negative impact on surrounding property values. Dr. Baron Gafford, considered a preeminent expert and the research of the photovoltaic heat island effect, testified on our behalf. His research team has studied the heat island effect and determined the degree and conditions of which a PV system might alter local climate conditions, ultimately publishing his findings in an oft-cited research paper. In Dr. Baron Gafford's expert opinion, the project will not result in the transference of heat onto adjacent properties. Tommy Cleveland is a former professor at NC State where he taught classes on utility-scale solar. He is one of the leading experts in the country on the potential health and safety impacts associated with solar developments. Mr. Cleveland's publications on the topics of health and safety have been cited by numerous national and state agencies. He provided substantial expert testimony regarding potential health and safety concerns associated with Mountain Trails project. In his expert opinion, the proposed project will not pose any adverse health or safety concerns to the community. We retained Mr. Michael Sveen to generally address the effects that the project would have on wildlife and to specifically respond to Hawk Mountain's concerns about potential habitat depletion, bird mortality, barriers to wildlife movement, and impacts to the Kittatinny Ridge important bird area. Now, as we noted during the hearing, all these concerns are relevant to the board's consideration of the application. However, we nonetheless submitted an expert report and testimony because it was made clear that this was important to the board and community. Mr. Sveen's expert testimony cannot be dismissed because he is from Canada and not Pennsylvania. As he humbly attempted to explain, the reason he was retained was because there may be no one in North America with more expertise with respect to these matters. As his testimony made clear, Hawk Mountain's opinions were unsubstantiated. Through his expert analysis, we demonstrated that the project will not have a negative impact on the surrounding wildlife. Now, it is important to understand the law concerning conditional uses, the applicable burdens, and several presumptions at play. We've heard some people note that already today, and we will address all of these in greater detail in our written submission. But I ask you now to take notice that a conditional use is not an exception to an ordinance. A conditional use is a permitted use, legislatively allowed, where specific standards and conditions detailed in the ordinance are met. Here, the zoning ordinance specifically allows for the solar energy system use as a conditional use in the agricultural district, subject to conditions and standards set forth in section 615 of the ordinance. Please allow me to address each of these requirements briefly. First, the design, installation, operation, and maintenance of the solar facility shall conform to applicable construction, electrical, and safety industry standards, very importantly, including the National Electrical Code, the Uniform Construction Code, and the PUC's interconnection rules and regulations. Both the Gasperi and Frederick parcels are both more than 5 acres, and the lot coverage on both of these properties is not more than 20%. And this goes to your question earlier, because we had consolidated them both, and the panels were 20% combined, and then there was at the planning commission, we were told, no, you're gonna have to consider these 2 properties separately. Which, we didn't agree with that interpretation, but we went ahead and we revised the plan, so the lot coverage on each was less than 20%. All exterior electrical lines connecting to the system shall be buried below the surface of the ground where possible. The facility not only meets, but greatly exceeds all of the setbacks. No part of the ground-mounted system exceeds a height of 20 feet. It is important to note that the substation components are not subject to this 20-foot height limit. There are a number of reasons which we will address in detail in our written submission, but for this purpose, two of those reasons are there are exceptions in the zoning ordinance for towers and utility poles. Also, it would be impossible to comply with the National Electrical Code, which is the very first standard. No part of the system is proposed within a legal easement, right-of-way, or stormwater conveyance system. The facility is not proposed between the principal building and the street right-of-way. All of the mechanical equipment will be completely enclosed by a fence with a self-locking gate. A clearly visible sign concerning voltage will be placed at the base of all pad-mounted transformers and substations. The system is designed in a manner that avoids directing concentrated solar radiation and glare onto any adjacent property or public way. Now, as it pertains to glare, this is a subject that took up a considerable amount of time. It is also a prime example of the many good faith attempts Mountain Trail has made to educate and satisfy the community's concerns. This standard is satisfied because it's not possible to produce concentrated glare and radiation with a fixed tilt PV system. As Mr. Cleveland testified, the glare associated with this project is similar to the glare that you would expect from any of the hundreds of other fixed tilt systems across the country. There is nothing unique or harmful about the proposed glare. We demonstrated that there is no red glare, which is a type of glare that is prohibited by the ordinance.
Where in the ordinance is that prohibited?
What I just read is you're not allowed to direct concentrated solar radiation and glare. And there is no definition for glare. And as we've addressed, this goes to the statutory presumptions, which we'll address in more detail.
How do you address Mr. Fowler's position that your use of the terms concentrated glare is really a fabrication or a misreading of the ordinance?
The ordinance, to the extent that there's any ambiguity in any ordinance, it has to be resolved in the favor of the applicant, and that's statutorily provided for in the Pennsylvania municipalities.
I agree with you on that point, but what's the ambiguity that you believe exists?
I don't think it's a conjunctive. I think it's meant to be read in as exactly as it's interpreted. So,
and I assume that you'll have cites to the statutory construction and
yes,
support that position.
Correct.
Please continue.
As Mr. Cleveland testified, the yellow glare associated with the project is on the lowest spectrum of the yellow scale and is similar to the setting sun without the facility. However, because of the concerns raised by members of the community, Mountain Trail has committed to installing additional significant vegetative buffering beyond the requirements in the ordinance to further minimize any glare. Specifically, Mountain Trail has agreed to install vegetative buffer and screen at least 6 feet in height at the time of planning, which is a significant buffer in the areas recommended by Mr. Cleveland. Moreover, and not required at all to demonstrate compliance with the ordinance, Mountain Trail has committed to providing up to $5,000 in financial support to neighbors who wish to install additional landscaping. Prior to construction, Mountain Trail shall post a bond or other financial security in a form acceptable to the township to cover the cost of equipment removal. As Mr. Larios testified, Mountain Trail agrees to a condition that the decommissioning cost estimate for the project shall be carried out by an independent third-party appraiser, the costs of which are to be covered by Mountain Trail. Further, Mountain Trail is agreeable to a condition that the property it owns will be restricted to agricultural use after the facility is decommissioned. As required by the ordinance, Mountain Trail has provided the plans to local emergency services and will work with the same to develop and coordinate the implementation of an emergency response plan. As an aside, and objectively speaking, We believe that Mr. Cleveland's testimony made clear that many of the emergency concerns and hypotheticals that we heard throughout the course of the hearings were overstated. However, as Chief Ames testified, Mountain Trail has been working with the fire company and will continue to do so. To that end, Mountain Trail has committed to a number of proposed conditions, which include the following. Prior to operations, Mountain Trail shall provide training on responding to fires at PV facilities. Mountain Trail shall coordinate with the Union Fire Company number 1 to determine the appropriate equipment required for the project. And Mountain Trail shall make a $300,000 upfront contribution to the Union Fire Company number 1 and $50,000 annually for the life thereafter for the life of the project. And lastly, Mountain Trail shall submit a land development plan to be reviewed in accordance with the Township subdivision of land development ordinance. As was stated many times throughout the course of the hearing, that is where a thorough review of the plan is done, and matters such as stormwater, steep slopes, grading, those are comprehensively addressed. Under Pennsylvania law, Mountain Trail has met its duty of presenting evidence and burden of proof that the proposed use satisfies the conditional use criteria for a solar energy system. If our application was denied, I am confident that a reviewing court would agree and find that the application should be approved without condition. However, that should not be a situation we find ourselves in. In approving the application, this board has the statutory authority to attach quote-unquote reasonable conditions to its approval. We will address in more detail in our findings of fact and conclusions of law, but at last count, our proposed conditions of approval are in the neighborhood of 40, some of which I just mentioned, and many of which only meet the reasonable standard under Pennsylvania law because we are proposing them. Finally, we know that this has been a challenging and at times contentious process for all of us here. We understand that the objectors are not in favor of this project. And for that reason alone, this is not an easy decision. However, by placing conditions upon your approval here, the board has the ability to appropriately balance the interests of the public regarding the impacts associated with the project against the landowners and Mountain Trail's right to develop their property. While many residents may not believe such an outcome is in their best interests, it really is. It is also the right decision. Because the project has met the applicable ordinance standards and Mountain Trail has worked hard to address the community's concerns, we respectfully request that this board approve our application. I thank you all for your time and consideration.
Thank you, Mr. Gallagher. Any members of the board have questions?
I do.
Mr. Davis.
Yes, Mr. Gallagher, all throughout your testimony here right now, you refer to Mountain Trail Solar, but back in late 23 or early 24, the issue was brought up, that was talked about tonight with Leeward Energy. Are you retracting Leeward Energy out of this as a co-applicant, as you stated in prior testimony?
No.
No, you're not.
For terms of closing, I'm just generally referring to Mountain Trail and Leeward. I feel like we've been over this a number of times, are the same. For all intents and purposes, are the same.
We have, but my understanding is they're co-applicants. Is that the case or not the case for the record?
That is the case.
So, regardless of what way this decision goes, it's Leeward Energy / Mountain Trail Solar.
Yes.
Okay, thank you.
Thank you, Mr. Davis. Any other questions from the board?
Thank you.
Is there a rebuttal from you, Mr. Cluck, since you reserved time?
Yes, briefly. So, your pen? Nope.
Mountain Trail
Right.
LLC, Leeward Renewable Energy Development LLC are two separate legal entities. They're not one and the same. On decommissioning, the ordinance says at the time of zoning approval. It doesn't say at the time of building permits. So if they're going to have an estimate, and if you're going to approve it, they better be prepared to have a significant financial commitment. Lastly, the legal standards are clear. They have to meet the express standards. You've heard conflicting testimony from experts on both sides. Your job to determine which set of experts are more credible. We believe our experts are more credible. Thank you.
Thank you, Mr. Cluck. So as we previously discussed, findings of fact and conclusions of law are due, I believe we determined August 16th. Friday, August 16th, close of business, which is 5:00 p.m. Will be emailed to me. I will then distribute, probably not until the following week, but I will distribute to everyone all the findings of fact and conclusions of law. The township will then have a period of time to prepare and approve an opinion and a decision. Typically, that is 45 days. I believe we agreed to an extension to 60 days.
Sure.
Okay. So I appreciate a letter on this, but for the record, the applicant's agreeing that the township will have 60 days from August 16th to announce its decision and submit an appropriate order.
Yeah, and I will state that on the record, which is, I can give you a written confirmation, but stating on the records.
Agreed. Agreed. So at this point, I believe that we can do something that gentlemen, you may have been wanting to do for the last 10 months, which is that we don't need to announce a new hearing at this point, so you can adjourn these proceedings. What we will do is when we are prepared to announce the decision, we will notify the public. We will advertise that, and you gentlemen are certainly welcome to come in person, or you are welcome to participate via Zoom, because we do have the Zoom link for all of our meetings. So that's your prerogative. So at this point, Mr. Chairman, you can entertain a motion to adjourn the conditional use hearings for Mountain Trail Solar's application.
I'd like to make that motion that we adjourn the public hearing. Do I have a second? Second. All in favor, say aye. Ayes have it. Thank you, everybody.
Thank you.
It's been a long process.
Yes, sir.